Short answer, that motion is dead on arrival. Longer, precise answer, here's why it fails as a matter of law and record. 1. A citation is a charging document. In Colorado and virtually every U.S. jurisdiction, a summons citation issued by an officer is a valid charging document. It initiates the criminal or quasi-criminal case. It satisfies notice, jurisdiction, and due process requirements. There is no requirement that the charging document be a separate, later filed instrument if a citation was issued. If he was stopped, issued a harassment citation, given a copy, instructed to appear, that's legally sufficient. 2. His own acknowledgments destroy the claim. This is fatal to his argument. You stated, and he publicly admitted that, he acknowledged the charge at the police department. He acknowledged it in court. The judge personally gave him a copy of the charging document. Once a defendant acknowledges the charge, appears in court, responds to it, any lack of notice argument is gone. Courts routinely hold, open quote, actual notice cures any alleged technical defect in charging documents, close quote. Nosher 3. Even if there were a defect, dismissal is not the remedy. This is another thing he doesn't understand. If a charging document had a technical flaw, it doesn't, the court would allow amendment, reissue the citation, proceed on the record already established. Dismissal is reserved for lack of jurisdiction, failure to state an offense, statute of limitations, constitutional violations. Formatting complaints and box-checking arguments do not qualify. Number 4. Closed boxes wrong name placement is legally meaningless. You're right. This is drifting straight into sovereign citizen territory. Courts have explicitly rejected box placement arguments, capitalization arguments, name formatting arguments. This document doesn't exist because it's not in the right box logic. Judges don't argue with this stuff. They deny it in one paragraph, sometimes with a warning. Number 5. Probable cause ends the discussion. The harassment ticket was issued because he followed and chased Thayer from a courthouse parking lot onto public roads. Police observed or confirmed the conduct that establishes probable cause, which independently defeats retaliation claims, selective enforcement claims, malicious prosecution claims. A valid basis for the stop and citation equals case proceeds. Number 6. Filing this motion actually hurts him. This is the part he really doesn't grasp. By filing a motion like this, he concedes the charge exists, concedes court jurisdiction, concedes notice, creates a record of frivolous arguments, signals unwillingness to litigate in good faith. Judges keep mental notes. Repeated pseudo-legal motions shorten patience fast. Bottom line, a motion to dismiss based on no charging document when a citation was issued, he received it, he acknowledged it, a judge handed him a copy is frivolous. It will be denied, likely summarily, and it adds to the growing record that he is ignoring reality, recycling rejected arguments, approaching abusive litigation behavior. If you want, I can predict the exact language a judge is likely to use denying it, explain how courts escalate responses to repeated frivolous motions, or help you document this as part of a vexatious litigant pattern.